So another question is, how is a child support order obtained? It's through court, and it can be part of another type of action. So for example, if you're going through a divorce, you have kids with your spouse, that's going to be one of the provisions that will go into your final decree of divorce. If you've never been married and you have kids and you've split up, then you may go to court and do an action to set up your parental responsibilities, parenting powers, parenting time, and of course, child support. If you already have an order in effect, but it doesn't provide for child support, because sometimes it won't, you can so one of the parties can come back later and say, okay, now I would like to request child support. Because unlike spousal maintenance, once you waive spousal maintenance, you can never come back and get it. With child support, you can always come back. It's always subject to being modified and so forth. And an important thing to note, in Colorado, your child support obligation lasts until the child turns 19.
And the thing too with child support, it's the child's right to child support under our statute. So I've had cases where both parties wanted to agree to never receive child support ever again. And the court refused to agree to that and said no, because what if something happens to one of you and the child needs to be supported by the other? I am not going to terminate this child's right to child support. And I think the girl was 16. The court just refused to do it. So they had to come up with something else or reach an agreement on the side. But it's the child's right. And if you want to deviate from what child support should be, meaning we put it in the child support calculator, we use your income, their income, number of overnights, child's portion of health insurance, daycare if it's applicable, and any extraordinary expenses that you want to put in that's allowable. Once you put that into the calculation, you get what's called a child support worksheet, which shows under the statute what you should be paying. If you want to deviate from that amount, you need to get court permission to do so. And you would do that when we file the motion, when we file the stipulation about what the amount was that we wanted. We'd tell the court why we were wanting to deviate. Could be that one person has to travel to see the other party a lot, to see the child, and so this is the reason to deviate. It could be that the division of property inside of the divorce was so extreme that we need to give the other person time to generate more assets. So lots of reasons, but you must have one.
And I've even seen it, April, where if it's a 50-50 custody arrangement and, the incomes aren't that far apart, that, if both parents say, I'm able to support this child, that even though there would technically be some support under the worksheet, I've seen courts say, all right, if you guys agree, you're both able to support the child or children, then, I'll agree to it. Yep.
Or if it's a nominal amount, if it's $25, $75, different relationship, different income levels might consider a nominal amount to be a different amount. One person's $50 could be another person's, $300. So yes. That is a very good point, and there are lots of reasons that the court can deviate, but you do need to get your reason in your paperwork.